Strategic use of voluntary departure in removal proceedings.
Hi, I am Attorney Edwin Fogam, an immigration attorney. I want to talk to you today about the strategic use of voluntary departure in removal proceedings. So the question is it possible to strategically use voluntary departure in removal proceedings? Yes, answer is yes. What is voluntary departure and removal proceedings? Voluntary departure is a relief that can be granted to anyone who is in removal proceedings and facing removal and who doesn't have any other relief. You could ask the immigration judge to grant voluntary departure. This is a discretionary relief that can be granted. And why does this matter? This matters because voluntary departure does not have the same legal consequences as a removal order. A removal order or a deportation order will cause you to be barred from coming back to the United States for at least 10 years. And even after the 10 years, you will need to file a waiver to be able to be admitted back into the United States. However, if you are granted voluntary departure, you may come back anytime after you have left the United States, even within months, depending on whether you have another relief or the way you are coming back. Now, how can you be eligible for voluntary departure? There are a couple of things that needs to be established in court for the immigration judge to grant voluntary departure. First, you must agree to accept voluntary departure and leave voluntarily without being ordered within the period that is given to you. Usually it's between 90 to 120 days to leave. You must also have a means to leave, and also your proof that you have the documentation to leave the United States if you are granted voluntary departure. You must also be a person of good moral character. If not, the judge may not grant it. You must not have committed a crime in order to be eligible for voluntary departure. And you must also show that you are able and willing to afford your departure from the United States. Sometimes a bond can be requested. You can be asked to place what is called a voluntary departure bond. In other words, you put some money to show that you will actually leave the United States. And finally, you must waive your rights to appeal. Now, if you can do these things, if you can demonstrate this, the immigration judge can grant you voluntary departure. And the question becomes, why would anyone be seeking voluntary departure? From a strategic point of view, it can be very helpful. For example, if you have someone here who is petitioning for you, marriage, family-based petition, and you are not eligible to adjust your status and you are in proceedings and you don't have any relief, it will make sense to secure voluntary departure and then do consular processing when the petition is approved. There are other examples that can be used, or you may be going out of the country to work in a company or somewhere where you may need to be coming back to the United States for job-related reasons. Now, you don't want to be inadmissible. You don't want to have the bar of deportation. So you may want to consider voluntary departure. Now, one thing I always tell my clients is this is a very serious decision, because if you accept voluntary departure and you don't leave, it automatically becomes a deportation order, and you may not be ready for that, given that you had considered leaving and things like that. So if you find yourself in this position, make sure you consult a knowledgeable immigration attorney. You can consult us. We'll be glad to help you and take care of the situation. If this video helped you, share it and have others benefit from it. Also, you can call us on 301-608-1555, or you can shoot us an email, ekfogam@fogamlaw.com or info@fogamlaw.com. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.